District Court of the State of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good afternoon, everyone. Please be seated. Okay, we're on the record in case number CR 19-1535B, State of Nevada versus Stewart Handte. The court recognizes Mr. Kozak, if I'm pronouncing your name correctly, Mr. Handte, and the prosecutor, Mr. Stege. I set this hearing today because there was filed, on or about August 31st, a substitution of counsel, and ordinarily those are not of any particular concern to the court. Clients change attorneys from time to time. Clients also represent themselves from time to time, those that are legally able to, individuals as opposed to corporations, LLCs, things like that. However, in a criminal justice matter where we have somebody represented, it's a little bit of a more involved process. In fact, the court has reviewed both Nevada Supreme Court Rule 46.1 as well as the recently established Nevada Rules of Criminal Practice. And both seem to suggest that a hearing is needed, particularly under Rule 3.1 of the Nevada Rules of Criminal Practice, to make sure that a court order is connected with an attempt to have an accused represent themselves, particularly where, as here, Mr. Handte was accused, had counsel, sought to represent himself. Court had a hearing under Faretta versus United States. No, Faretta versus California, I should say, U.S. Supreme Court case, where the court determined that Mr. Handte was making a knowing and intelligent decision to represent himself. Knowing as in aware of his rights, intelligent as in understanding the effect. Not necessarily a great idea, but that's not the test. So we had a hearing. The court allowed Mr. Handte to represent himself, and his attorneys were relieved. Mr. Handte then found his way to Mr. Kozak's office. Mr. Kozak entered a notice of appearance and was representing him. And then apparently Mr. Handte now has desired to proceed without counsel. That led to the substitution of counsel filed August 31st. And that led to this court's order setting a hearing. So, first question is this a motion to withdraw, Mr. Kozak, or is this an agreement between you and the client for him to move forward self-represented? What's the answer to that, please?
The answer is it's not a motion. He's decided he wants to proceed on his own. Made that quite clear to me. His theory of how to defend himself is miles different than my theory of how he proceeds. So he instructed me to do no further work on his behalf, and he was more than willing to proceed with his idea of how to represent himself in this case.
Okay, well, so Mr. Handte, is that accurate with respect to what your attorney just said? You'd like to represent yourself again?
Correct, Judge.
All right, do you understand that we have trial set for November?
Yes, I do. And I have had filed court documents, one filed on June 24th, that attested to the proceedings coming up.
Well, there is a motion to dismiss the case. That's under submission. But if the motion is not granted, trial is set to begin November 14th. Are you aware of that, sir?
Yes.
Okay. If I allow your attorney to withdraw, and I have to, if I allow your attorney to withdraw because you'd like to relieve him of his responsibility to be your lawyer, then we're going to conduct a similar hearing pursuant to Faretta versus California that we had several months ago. Do you understand that?
I don't think anything changed, Judge.
Well, that's the issue, though. I don't know if things have changed. I don't know if this is a knowing and intelligent decision on your part. Maybe something changed in the last 5 months. This hearing, this Faretta hearing, this canvas, this question and answer session is designed to protect you from yourself, from making a decision that's not knowing or intelligent. It's not designed to pester you. It's not designed to challenge your legal right to represent yourself. It's designed to make sure that really nothing has changed in the 5 months or so since we did this the last time. But I want to mention something to everyone here, and I'll hear from Mr. Stege in a minute. If we have this hearing shortly, and if I determine that you knowingly and intelligently want to waive your right to counsel and represent yourself, it's not likely that if you decide to hire new counsel again, Mr. Handte, that the trial date would move. Because the court has discretion, even when somebody wants to bring on counsel in a criminal justice case, especially after you've had counsel, then it would be twice, to keep the trial date, to make sure that whoever would come in on your behalf, if there is somebody, takes it subject to the existing trial dates. So do you understand that if I let you move forward as self-represented and you change your mind later, there's no guarantee whatsoever that this November 14th trial date will be postponed. Do you understand that, sir?
Understood.
Okay. And the court, in making that statement, is guided by the recent Nevada Supreme Court case of Brass versus State of Nevada, which filed April 7th of this year, found at 138 Nevada Advanced Opinion 23. So, Mr. Stege, the procedure, one more thing. So, Mr. Handte, you have been filing on your own some documents in this case recently, but I've stricken them. I want to make sure you know that. I've stricken them. They're gone. They have no legal force in effect. I believe one was a motion to change venue, and I believe one was a motion to disqualify the court. I struck those. I struck those last week because you're currently represented by counsel. You have no legal right to file anything on your own behalf. Do you understand that they've been stricken?
I understood. I've read Rule 3. Once the court makes a determination, I'll refile the motions.
Okay. But nevertheless, you were here to attempt to serve them as is required on a motion to disqualify. That was this morning, is that right?
Correct.
At a time that you knew that they had been stricken, you were attempting to serve them?
I didn't know specifically the language. It just said exceeds security limits. That's all it said.
Well, didn't your attorney advise you that your motion to disqualify the court had been stricken, or your
No.
motion to change venue had been stricken?
No.
When did you first learn that those had been stricken?
But you just said the word stricken.
Right now, for the first time?
In my eFlex account, it says documents exceed security level. That's all it says. It doesn't say stricken, it doesn't say anything. I got your motions this morning, and I read the verbiage in that. So between now and this morning, that's what.
That's when you learned? All right.
Correct.
And they're not my motion, the court order.
Court order.
So, Mr. Stege, procedurally, do you see a different path forward that you believe the law would require or otherwise allow, that you think the court should exercise its discretion to follow under the circumstances where we have somebody who wants to fire his attorney, wants to represent himself? Is there a way forward procedurally other than a new Faretta canvas?
No, I don't think so. I think that is the right path. And of course, the rules and case law tell the court that a canvas ought to be held. I think, given the fact of a relatively recent canvas, that may be abbreviated if the court wishes to do so, but I think that is the best course at this time.
Okay. All right, so Mr. Handte, that's what I'm going to do. I'm going to ask you questions again under Faretta versus California. Most will sound redundant to what we already went through, but for the reasons I stated, I don't know what's changed, if anything, in your view or your understanding in the last 4 or 5 months. And if nothing, or nothing substantial, I'll grant the request. Your counsel will be relieved and you'll be representing yourself. On the other hand, if I come to the conclusion that there have been changes and that your decision is not knowing and intelligently made, I may say no. And if I say no, then Mr. Kozak remains your attorney unless you substitute with somebody else. So we'll see where that goes. But I am going to put you under oath to make sure that your answers to my questions pursuant to Faretta are that you're under penalty of perjury when you answer them. So if you please stand up just for a moment, sir, raise your right hand, address the court clerk, take the oath of witness.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
All right, thank you. Mr. Handte, if you wouldn't mind, just remain standing just for a couple minutes here. Are you currently sick or injured in any way?
No,
Are you taking medicine for any reason that makes you groggy or unable to understand what the court's doing?
no,
Is it your desire to release Mr. Kozak as your counsel of record and proceed with self-representation?
yes,
Do you understand you've been charged with 3 counts?
I do.
Do you understand that count 1 is conspiracy to commit second-degree kidnapping, where if convicted and if you were sentenced, the sentencing range under Nevada law is 1 to 6 years in the Nevada Department of Corrections?
I understand each charge against me, Judge.
All right, I'm gonna go through the other 2 as well, though. Do you understand that count 2 is a charge of burglary, which if you were found guilty and sentenced, the sentencing range under Nevada law is 1 to 10 years in the Nevada Department of Corrections?
Yes,
Do you understand that as to count 3, Mr. Handte, you were charged with second-degree kidnapping of an older or vulnerable person, which if you were convicted of that category B felony, the sentencing range is 2 to 15 years, Nevada Department of Corrections?
yes,
Do you understand that in the event you were convicted of all 3 and you were sentenced and you were handed the maximum by way of sentencing by the court, and they were to run consecutively, that the maximum sentence you could receive would be 31 years in the Nevada Department of Corrections? Do you understand that?
yes.
6 plus 10 plus 15. Do you understand that, sir?
Yeah, I did it in my head, Judge.
Okay. Do you understand that self-representation is often unwise, and a defendant may conduct their own defense at their peril? Do you understand that?
To a certain degree,
Do you understand that if you represent yourself, you are responsible for knowing and complying with the same procedural rules as attorneys and cannot generally expect help from the court in complying with the procedural rules?
understood.
Do you understand that if you are convicted of 1 or all of these counts after representing yourself, you will not be allowed to complain on any appeal about the effectiveness or competency of your representation of yourself?
Makes sense, yes.
Do you understand that Mr. Stege is an experienced prosecutor?
I understand he's had knowledge and experience in this field, correct?
Do you understand that an accused who is not as familiar with legal procedure or legal authority as a prosecutor may not make effective use of all the legal rights, remedies, and arguments otherwise available to them?
It can vary, I understand that.
Well, you understand that's a risk that you're taking by representing yourself.
True, to a certain degree, yes.
Would you remind me, please, your age, sir?
62.
And are you a graduate of UNR?
I am,
And what was your degree in?
criminal justice,
And you would have been involved in law enforcement as a professional for how many years?
30.
Has anyone threatened you or coerced you or anyone who you care about to make you seek to represent yourself in this case?
No,
Are you currently undergoing any care or treatment for mental health disability?
I'm seeking evaluation.
Have you ever been advised by anyone that you are not competent to proceed to adjudication?
Not one person.
Do you understand that you will have privileges to use the Resource Center, the Law Library here in the Second Judicial District Court, like anyone else, but the privileges will not be expanded. You won't have additional hours, weekend hours, things like that, that are not available to other people.
I have to get permission to come down here, so I understand the process, yes.
Well, you can come down here if you want to serve documents on the court, then generally we need to know that you're coming. But in terms of coming into the building, you're free to come in the building just like anybody else.
That's not what was told to me. I have to.
Well, that's the order of the court, so I'm making it so. Do you understand that?
I do now.
All right. Do you understand that the court has the right to appoint a backup counsel, assistance counsel in the event I thought it was just and fair to do so? Standby counsel, I think it's also called.
I've heard the terminology of counsel, yes.
Well, let's use the term standby counsel, which people are most familiar with, which means if I thought it was in the interest of justice, I could appoint an attorney who would not provide legal advice to you, but would be there in the event the court called upon him or her to step in if something happened. Do you understand that?
I do,
You would not be charged for that. Do you understand that?
yes.
Do you understand that if you represent yourself and in the court's estimation you start behaving in a way that's counterproductive to the administration of justice, disruptive, or any way attempting to impair the ability of both parties here to go forward, that the court has a right to terminate your own self-representation and then require you to be represented by counsel. Do you understand that? I know that was a mouthful. I can say it another way if it was confusing.
Slightly confusing, yes.
So here's a shorter version. If you start doing things that the court feels are designed to in any way inhibit the fair administration of justice, if you say things, do things, disregard court directive or order, start acting out, start using words that are inappropriate after being admonished, or we have a discussion, then if it comes to a point that I think the administration of justice is being impaired, I have the legal ability to say your self-representation ends, you now are going to be represented, and then we pause the trial and somebody's appointed for you. Do you understand that?
Does that preclude administrative actions that I can take and seek upon my own?
Well, that's a tough question for the court to answer. Each case turns on its own. Usually that particular rule I've just stated comes to bear if somebody is disruptive. If the court directs them to sit down, they don't. The court directs them to stop talking, they don't. Somebody tries to ask questions that they know are inappropriate after the court has directed them. Things like that. Things designed just to get attention. Things just to make the process disrupted, unbalanced, and not designed for the fair administration of justice, but for other purposes. Then at that time, among other remedies, the court can say, you don't represent yourself anymore if somebody's being appointed. That's one of the reasons standby counsel is often appointed for somebody who represents himself in a criminal case, so they can come in right then and there after a couple-hour break, as opposed to taking a several-week break to let them get up to speed. Do you understand that, Mr. Handte?
In a roundabout way, I do.
I'm not anticipating anything like that with you. I'm not suggesting that would be in play here. I'm just saying that, as I do with anyone who wants to represent themselves in a criminal justice matter, the court has a right to step in and have them be represented by an attorney if circumstances so warrant. Do you understand that?
Yes.
Fair enough. All right, the court finds that Mr. Handte is competent to waive his constitutional right to be represented by an attorney in this case. The court further finds that he does so freely, voluntarily, and knowingly, with full appreciation and understanding of the waiver and its consequences. Mr. Kozak, your request to withdraw or with the consent of the client is granted. Are you relieved from any further duty or responsibility in this case? Now, just thinking out loud here, in the event the court seeks to appoint standby counsel, are you available? I'm assuming you are because you wouldn't have accepted this case knowing the current trial date of November 14th if you had plans that were not movable during the time that the trial is set. Does that remain the case, sir?
No, I'm afraid not.
What if I hadn't granted the request today?
Well, since that time, we have an important legal malpractice case that's been rescheduled in federal court.
Oh.
They juggle these dates over in federal court because of the pandemic. So we were suddenly notified that we're on standby on November 15th for this case. So if the trial date is moved and you find he needs standby counsel, and I am available, then I would be agreeable to that. But November 15th is a date that, in a case that's been moved like 4 times. This is the 4th, so I'm really hung up in federal court that week.
Understood. When do you believe you'll know if that case is go launch or not?
Well, I think it's pretty set in steel right now because of the previous
Continuances?
over which we had no control. I mean, the court tells you, over in federal court, this is when you're going to go to trial. You don't have any say because of the pandemic and all the backlog of cases. And I guess they call it a trial stack. So this is what's happened. But if the trial date is moved, yeah, then I would be available to standby counsel if you determine it's necessary.
Okay, thank you. All right, let's talk about some further logistics. So again, we're currently set for trial November 14th. We are also set for a final pretrial conference October 24th at 4 p.m. Followed 2 days later with a motion to confirm October 26th at 4 p.m. So Mr. Handte, let's talk about the pieces of paper that are currently live in this case. The state recently filed a motion to, I think, admit other acts, Mr. Stege?
You're right, yes.
All right, so normally a response from the defendant would be due pretty soon because that was filed about 10 days ago.
It's due 10 days afterwards, which I believe would be the 21st.
Which is later, it's Wednesday of this week. So I'm going to assume, unless you tell me otherwise, Mr. Handte, that you would like more time than the 21st, 2 days from now, to respond to the state's motion to introduce evidence at trial of some of your other legal matters.
I would like an extension of time, yes, correct.
All right, so here's what I'm gonna do. I'll have your opposition extended at this time 1 additional week. So instead of being due this Wednesday, it'll be due the Wednesday next week. Second, you have a motion to change venue. You saw, as we talked about briefly, I struck that because you were represented. You can't file things on your own. You also have a motion to disqualify. Now, you've indicated you plan to refile that. Let's just focus on the motion to change venue. One option that the court has is to not put Mr. Handte through the time and expense of refiling the motion to change venue, deem it filed as of today, and then start the state's time running as of today to respond. Did you respond to the motion to change venue already?
I did respond, and then earlier today I filed a withdrawal of the response to both of the motions.
Well, the court could then, with both sides' agreement, deem the motion live, deem the response live, and send Mr. Handte, give him 10 days from today, so say by Friday of next week, to respond to the motion to change venue, so we can move this along. Any objection, Mr. Stege, if the court approached it that way?
If I hear the court saying that sort of not rescind, but withdraw the court's motion striking them, treat them as still in play, my only concern is that you usually do not get 10 days on a reply. A reply is a short
Or maybe the
response.
Wednesday of next week.
that's, I think that would be appropriate. We adopt that Wednesday of next week for any outstanding responses from Mr. Handte, although I think that would be appropriate.
All right, so I want to make sure we're understanding. You filed a motion to change venue. I've said it's stricken because you can't file it on your own. But to move things forward in this case, because trial date is in November, if the case is not otherwise dismissed, the court could rescind that order and with respect to the motion to change venue, deem it filed when it was filed, deem the response to have been filed, allow Mr. Stege to withdraw his request to withdraw the opposition, and deem your reply next Wednesday, same as the response to the state's motion for other acts. Again, a lot to digest here, but do you have any objection if we say your motion to change venue is live and you have until next Wednesday to respond to what Mr. Stege filed?
Acceptable, no objection.
All right, so ordered. Next, is a motion to disqualify the court. Now, what happens if that's live, this court has to stay further activity on this case until another judge looks at this court's actions and makes a determination whether this court can fairly proceed. I'm not prepared to withdraw now the order striking that. If you want to do it again, do it again. File it, you can have it served. If you want to serve something on my department, then when you come to the courthouse, they need to escort you up here. That's how it works. You don't need an escort if you're in the building for other lawful purposes. But that one, I'm not going to rescind the prior order striking it because you weren't represented. So if you're going to file that, do so promptly, and then the court will do what the law requires. My further action on this case will be stayed, and it'll be referred to another judge.
Understood.
All right, Mr. Stege, any questions about that?
Yes, because I suggest that the court read my moving papers on that subject, because I think, one, it's the subject of its, the defendant could be held in contempt of court for doing that. Because there's a prior same subject denial of that motion, this area of law is clear that if a
Well, wasn't that Mr. Hilligis's?
in ordinary courses, yes. However, Mr. Handte's, the fullness of his response is adopting the same arguments that Hilligis was unsuccessful.
Well, what you're saying is it looks like some gamesmanship and not sincere, but I'm not
Right.
prepared to make that determination. If Mr. Handte wants to pursue a request to disqualify this court because he finds that the court cannot be fair and impartial or has otherwise done something that would impair his ability to get a fair trial, he can pursue it. So I'm not prepared to say that automatically that's stricken or otherwise inappropriate. What I am going to say though is I don't want to deem it retroactive to the date he filed it because these orders I've just entered would then be invalid. So he has to refile it, and at that moment, if he does, then things are stayed until another judge looks at it. Okay? All right. So,
That, Judge, just to clarify, that was Mr. Hilligis that filed that specific.
okay, but you heard what
I heard
Mr.
his
Stege
argument.
said, so I'm not gonna repeat it. And I'm not trying to lobby you one way or the other what to do. Because Mr. Handte, the court's gonna make sure you get a fair trial in this case. Okay? If somebody believes that I've done something that should legally disqualify me, I'll abide their decision and you'll have another judge. In the event I can move forward, I'll do my best to make sure each side gets a fair trial. Okay, with that, the next time I see you, unless and by the way, that means the motion to dismiss, if you follow this motion to disqualify, the motion to dismiss, which has now been submitted by the state, because I gave the state an opportunity to respond to things that Mr. Kozak may have said that they were seeing for the first time. That just stays held in abeyance until this court or the new judge take it up. So it'll just be out there. All right, with that, thank you, everyone. That will conclude this hearing, and I wish everyone a pleasant afternoon. The court's in recess.
All rise.